Yes, sir. Thank you, Your Honor. Good morning, Justices. My name is Carmen Frateroli, and I represent Attorney Tom Kiley on this matter.
I have one question
Sure.
about the facts. How many lawyers are there in Mr. Kiley's firm?
At the time of the contract, there were Mr. Kiley, who was the principal partner, Pamela Swift, who was a minor partner, and I believe Tom Kiley's son, who was a young lawyer, was just starting at the firm.
The letterhead has also Mr. Cranny. There's 4 people on the letterhead at the time.
That may be. I may have missed that, Your Honor. So there may have been.
Well, but that could be very important. Was there evidence about that? Was any of that before the judge?
No, and that's part of the problem. None of this was before the judge. In fact, none of the issues concerning deterioration or the relationship or the attorney-client relationship of these two people was ever really before the judge.
So the judge didn't have any information about how many other people were in the firm?
I don't believe that. He may have read the letterhead, but no, there was nothing. Because I was there at the first time that Mr. Kiley was asked to appear.
So if we agree with you if we agree with you that the contract was not with Mr. Kiley personally, despite the fact he signed, if we agree with you that he signed only as a principal of the firm and not, so there's no contract with him personally, then would we have to remand this to the judge to make a decision based on a correct application of the law?
I hope that you don't do that. I understand that that's a very likely.
If there's one big question, at least to me, is whether there's another person in the firm who could take this over. Now, you aren't even sure, you say, about this last person that wasn't before the judge, and you don't really know.
No.
Certainly his son, it seems to me, doesn't seem able to, but I don't know how we can say. I mean, if we say that this was a contract with the firm, there may be somebody else in the firm who has to take over, but we don't know.
Well, you've made the leap, Judge, and a leap that I hope that this Court doesn't make, and that is that such a contract as you've seen in front of you, where a client signs a contract with the firm, binds every partner or every capable person in that firm, whether it's 100 partners or 1 or 2.
Doesn't it bind the firm ethically as a legal enterprise? This isn't a commercial contract?
Of course it does, Judge, because I'm honored to be a lawyer, and I concede that it's a privilege for us to be attorneys. I concede that this is appropriate for a profession to be controlled by this court, but I don't concede that we have no rights. Yes, there was...
But wait, isn't there a rule that says that you can't withdraw unless the judge allows you to withdraw?
Absolutely.
So doesn't that indicate that you just don't have the right to withdraw willy-nilly?
Absolutely.
Okay.
The key here, however, Your Honor, is that he did not appear, so there is nothing to withdraw from.
But the firm has a contract with the person.
Absolutely. And I agree that there's a valid contract. I've said it from the beginning. But there's a huge difference between having a contract, whether it's with a law firm or whether it's with General Motors or whether it's with whoever, on the one hand, and perhaps having a breach of contract action. Mr. McGibbon very well may have a breach of contract action against the LLP. But that's a big difference from forcing, against his will, a person who has not filed his appearance.
But you just changed the story. It's the firm. It's not forcing a person. It is forcing someone in the firm to appear.
I think the attorney-client relationship is a sacred and fiduciary one between one attorney and one client, not with the firm of Hale &
How can you
Gore.
say that when you're also saying that Mr. Kiley did not sign as an individual? He signed on behalf of the firm and Ms. Swift was representing the client at one time. It isn't an attorney-client relationship with Mr. Kiley, you agree. Even though he signed it was with Ms. Swift, so it isn't with one person.
The contract, in my opinion, Judge, was with the firm. And
Okay.
Mr. Kiley never filed his appearance. A lot of what has been written, both in my brief and the amici briefs, okay, the amicus briefs, seem to have to do with the issue of withdrawal. And I have no doubt that the courts of Massachusetts, and rightly so, have the right, because ours is a profession and not just some blanket, you're hiring a snowplow company, have the right to prevent a withdrawal of somebody who has filed an appearance.
Did Ms. Swift file an appearance?
Absolutely.
Okay, so the firm is in.
I disagree.
I wanted to ask you that, related to that question, because I didn't see the complaint in the record, and maybe it's there. When she filed the complaint, the malpractice complaint, did it say Thomas M. Kiley and Associates and then her signature, or did it just say Pamela Swift?
I don't recall it, Judge. My guess is that it would typically say Thomas M. Kiley and Associates, LLP, by Pamela Swift.
Okay.
But my understanding is, and in response to all of this, is that it's Pamela Swift who filed her appearance, not Thomas Kiley individual. And it's Pamela Swift who, at first, if you recall, Judge Cornetta, and perhaps rightly so, denied her motion to withdraw.
Right.
And then she came back. And at the second hearing, this is sort of critical to maybe one of the side issues in this case. At the second hearing, Mr. McGibbon said something like, I'm discharging him. We don't have a transcript. And on the basis of that, which is one of the bases of 116, Judge Cornetta allowed the motion at that time and then ordered everybody to show up. And Mr. Kiley did show up, and I showed up with him. And at that time, all that really was before the court. There was no evidence of deterioration. There weren't those 6 documents that Mr. McGibbon later then sent to the other side unsolicited. There was just the contract, the contingent fee agreement. So it was at that time, based upon and I know that you may consider remanding this thing, but I think you have enough not to. There was no evidence there upon which the court could make a determination as to the relationship. But clearly he did allow Pam Swift to withdraw at a time when there was no one else, no successor counsel filing an appearance.
But you have a contingent fee agreement that is with the firm. You don't disagree with that, right?
Yes.
And then you have, and the contingent fee agreement is we're gonna file this, we're gonna do this suit for you, right?
Yes.
They file the suit, and then you say, well, yes, although the contingent fee agreement is with the firm, we're switching horses now because with the suit it's only Pamela Swift. I mean, there's something isn't connecting there.
Well, I hope that you can connect the dots at some point, because to me it's relatively clear. And the question that's before us is whether or not, under these circumstances, under these facts, the courts, the Superior Court, can order an attorney involuntarily to come in and try a medical malpractice case under these circumstances when he has never filed an appearance. I agree that a lot of times you see these complaints where 2 people, a partner and an associate, will often sign a complaint. It happens all the time. And under those circumstances, if one leaves, the other person is still in. But that didn't happen here. Tom Kiley never filed an appearance.
So you're saying that for a med-mal case, if there is a law firm representing the plaintiff and the attorney who is handling the case who's filed an appearance, let's say who leaves for California, on the eve of trial, the judge is not able to say, listen, firm, you signed up for this. We have a trial date set. The defense lawyer is all set and ready to go. You find somebody from that firm to try that case. You're saying a judge can't do that.
To be consistent, I am saying that, Judge. You also added a new element on the eve of trial.
That's a question as to whether it's appropriate judgment. But
Right,
you're
right.
saying the judge doesn't have the authority in any event to say you find somebody in that firm to file an appearance to try this case.
I am saying that, Judge.
If God forbid, but if Attorney Swift had died, same result?
Yes. Died, left, decided not to practice anymore.
So you mean if a client makes an agreement with a firm and the attorney who has been representing him or her dies, then the client has nothing left?
Well, it has his case. The person has his case left.
But he doesn't have an agreement with the firm to go on?
He has an agreement with the firm, and again, he may or may not decide on a breach of contract action. But we're talking here
Well,
about
I'm
the
talking
power.
about the case, going forward with the case.
I understand. We're talking about the general superintendents of the courts. That's what's brought us here today, obviously. And whether or not, I'm sorry.
No, go ahead, finish.
And whether or not the courts can force some other lawyer who has not filed an appearance to come in and take over and try this case.
Now, what happens, could the client in this case just sit back get defaulted for having done nothing, and then file a lawsuit, a malpractice suit against the firm.
Very possibly, yes. In fact, I do a lot of that kind of business. I represent a lot of lawyers, and I'm involved in a lot of legal malpractice cases as well. And yes, there is a possibility. It may not be legal malpractice, because that's the average qualified practitioner and all of that, but it may be breach of contract.
Tell me what's wrong with requiring the firm to continue on with the representation of this case, where they allowed an associate to file a pleading on the firm name, even if no other partner had signed it. What's wrong with requiring this kind of servitude? What's wrong with that?
Because I think it is servitude.
But it's not. Haven't you implicitly agreed to undertake continued representation by allowing the associate to sign on behalf of the firm?
Let's go one step further,
Yeah.
Judge. Hasn't an opera singer agreed and signed a contract to sing and perform? The answer is absolutely yes.
We don't license opera singers.
I understand that. And
We license professional lawyers. We have a whole code of ethics. It's on that we decide this case.
I started off by saying that it's an honor, and I accept all of that. I'm just trying to suggest that at some point, we lawyers have rights as well when it comes to something like this.
But that firm has filed the lawsuit through Ms. Swift. So that firm has some obligations here, isn't that right?
Well, let me ask the dumb question, I suppose, and maybe this is where you're heading, Madam Justice, is what if we have a 100-person firm with 50 partners and 50 lawyers, and it's hail and door by Jim Smith, and Jim Smith died, or Jim Smith left, or whatever, midway? Or what if, for example...
I'm not too troubled with the idea that I would say to Hale and Dorr, or Wilmer Hale, you need to have somebody come in here and take this over.
We do it all the time.
Well, then you're imposing on one individual, an attorney, who may not want to do something, to come in. And remember, too...
No, because anybody in the firm can come in.
Well, I appreciate that, but in our situation...
But
we
isn't that a
really-
decision
Well,
the
that's
firm
why I-
has to make before the firm takes the case? That when the firm takes the case, the firm takes the case. It's not Sally Smith takes the case, the law firm takes the case, and there are responsibilities the law firm accepts when it takes the case.
It did, and if it breached its responsibilities, Mr. Justice Gantz, then it could be responsible or liable in a breach of contract claim.
I would agree with you. If this had all happened, let's say, before the lawsuit got filed, Pamela Swift says, I'm taking a sabbatical from the practice of law, I'm leaving. Mr. McGibbon, you've got to find another lawyer. Clearly, Mr. McGibbon could not go into court and say, I've got this contingent fee agreement, you, judge, now make somebody else file this lawsuit for me. That clearly can't happen. But the lawsuit was filed in the name of the firm and by her.
Well, I guess my question would be, why is there a difference between having filed the lawsuit or not?
Because once the lawsuit is filed through the firm, then it comes under the rules of civil procedure, and you can't, you've got responsibilities to the ongoing litigation.
I'm getting the sense that, I'm not making much headway here, but I'm getting the sense that we obviously are in a profession that's controlled by this court, and there are certain rules and regulations that we have to live by. So that it seems to me the leaning here is that there's a contract with a firm, and therefore, if one lawyer doesn't do the job, you can go make another lawyer in that firm do the job. Or are you suggesting, Madam Justice, that the only difference in what I'm saying is the filing of a lawsuit? That pre-lawsuit, the law firm can walk away and say, we don't like you anymore. Sue us. Doesn't matter.
Well, the lawsuit, I'm just saying to you that I don't think a judge could, if the lawsuit hasn't even been filed, I don't think the judge is implicated. You may have problems with the Board of Bar Overseers. You may have problems as a contract, but I don't think you're not in the same situation as you are here because this lawsuit was filed.
Mm-hmm. Was the evidence of the email information that the client sent to the adversary, was that before the judge?
No. What happened...
Well, if the answer is no, it's no.
Well, yeah. What happened is he sent it later to the other side. It wasn't there at the time. There were two hearings with Justice Cornetta. One with Pamela Swift, where he allowed, well, three, I guess, denied, then he allowed, and then another one where we had everybody before him. And I was at that one, the last one. The last order was a motion for reconsideration, which he denied without hearing. But it's after that first hearing that Mr. McGibbon decided to send this material.
But
which is
before the second hearing.
No, he never had any evidence in front of him.
But there was no evidence before the judge. That's what I'm asking.
That's correct. And that brings, I know I'm done in time, but that brings the last little issue here, and that is the 116. I mean, if this court would order him to appear, I assume he might have to file, he'd be almost mandatory, he'd have to file a motion to withdraw and bring up all of these things. And the other possibility, of course, is that you remand this to the court for some kind of a finding under 116. And if that happens, that happens. I want to thank you all for your time.
I just had one procedural
Sure.
question. You mentioned amicus briefs, and I'm only aware of one. Is there more than one that I'm just not aware of?
Yes, maybe it's been timing. I filed a brief.
Right?
No one else did except two amici. You may not have seen them. One came in about 10 days ago, and I know you had a 2-week time limit. One came in about 10 days ago,
So we have one from Mr. Johnson.
Mr. Johnson's, and another came in within the last day or two from a group of Boston lawyers, Mike Moen, Elizabeth Mulvey, Neil Sugarman, and a couple of others who, I know it's late, but it came in.
Okay, I haven't seen it, but that's...
Okay, hopefully it's in your package there somewhere.
Thank you.
Thank you very much.